do this. All right. I'm going to bring on, oh my gosh. This is not even really happening, y'all. Mr. Robert Barnes, how you doing, buddy?
I'm wearing my CIA T-shirt in honor of David Hancock, who's the person who has hijacked the Rittenhouse defense. He'll know what the reference is for.
I have no idea that you even owned a T-shirt. I've learned so much today.
Exactly.
Fight, 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 fight.
Hypocrisy.
Here I am. This is the first time in my life I've been more formally dressed than you ever.
Exactly.
Well, welcome to the show, man. I saw you in the chat. There are a whole bunch of people saying bring Barnes on, so I'm really glad you had some time tonight. What is your thought on how things are going? If you want to comment on my assessment, that's fine. If you want to just go ahead and start fresh and make your own, please do. I'm anxious to hear some other opinion on this.
No, I think your assessment is correct. The facts and the law still favor Kyle. That hasn't changed. But what changed was another monumental defense mistake that to me is ineffective assistance of counsel. But the courts, of course, say you can sleep through a death penalty trial, and that's not ineffective assistance. So that's why it's not an effective legal remedy. By the way, did you see? I haven't seen any evidence that they actually ever filed the motion for mistrial. I thought they were going to argue that today. It wouldn't surprise me, by the way, if they withdrew it, because that's their mindset. Their mindset at the very beginning is that they can't lose this case. And consequently, they've taken complete undue risks because they didn't think they could lose.
Yeah, I saw the volume issue. It is now remedied. Sorry about that, guys. No, I think I haven't seen the mistrial either. In fact, they adjourned court, and I thought they went to lunch. Not only did I think they went to lunch, I'm pretty sure Law and Crime and PBS, who sat there with their live feeds going for the next hour, figured he said jury instructions and motions. And so they must be coming back. And so we sat around, talked for an hour and a half, at least, until it's like, no, I guess court is done for the day. I'm waiting for the mistrial. The provocation charge, at least in my assessment, and I'm not an expert on this, so I wanted to ask, does that torpedoes the motion to dismiss, right? Like now that we have a fact question for the jury on the murder charges, you've basically, that's handed over to a finder of fact. Is that accurate?
Yes. If he finds there's sufficient evidence to give it to the jury, then by definition, there's not a directed verdict.
Right. And
they still have the motion for mistrial with prejudice. Still
right.
available.
That's a separate issue. And that is on this, the gross violation of the Fifth Amendment rights of Kyle Rittenhouse, and
it was part of a sequence. I had wanted them to start laying the groundwork for this, also laying the groundwork for provocation. If they had laid the groundwork for misconduct, laid the groundwork for why provocation has no application and how it will be misused and abused, and laid the groundwork for how prejudicial pretrial publicity had been for Kyle and Kenosha, then none of this would be happening, because the judge is assuming what he's getting off of them, that they are very confident that they're going to win the case by the way they're behaving and handling matters. He assumes the same. That's why he's willing to submit it to the jury. He would much rather have a jury acquittal than a judicial dismissal. And right. And that, like, I had this exact conversation with Richards. Is like, shouldn't we bring up to the court? The court clearly doesn't know that, almost 2/3 of Kenoshans, because of pretrial publicity, have prejudged the case. And he basically didn't understand polling. That was his answer. It was like, oh my God. He also, when I said AI, he said, "What's AI?" And I was like, "Oh, you're the guy responsible for video technology, and you don't know what the words AI mean." I was like, "Oh, this is." But I figured as long as we got to pick the jury, even an idiot could win this case. A true idiot. I'll say from now on is even a Richards could win the case, because the facts were so strong, the law was so strong, and Kyle was so innocent. You had to have an extraordinarily innocent guy, not, kind of innocent, not maybe innocent, not under the circumstances innocent, a kid who is just purely innocent. The reason why he even got caught in that situation is because of how innocent he was. Yeah. He was naive and idealistic. I mean, the photo that they're freezing, that they're claiming he magically shifted his gun and somehow raised it with his left hand and then magically shifted it back to the right hand. That's him in shock. He drops the extinguisher because Zeminski makes the threat. And he's like, he doesn't comprehend that. The idea that someone would want to kill him. Well, why would someone, that's why he was there that night.
I'm just putting out fires here.
Yeah.
Why?
Exactly. And then Rosenbaum comes behind. It was an ambush. I mean, the whole thing was a Zeminski. It was an orchestrated ambush with Zeminski and Rosenbaum. They were waiting to get him, particularly given Kyle looks like a big kid. It's not a surprise. The pedophile, that triggers their deepest anger, and it triggers the Antifa sociopathic criminal rage that those people were demonstrating that night. And Binger knows that. They know that they're faking the video, but it's just because there's been an incompetent technical defense. And especially, I mean, throughout the trial, they were letting in all this video with all this prejudicial hearsay that was impermissible. It wasn't relevant. It was more prejudicial and more confusing than it was probative. It was lay opinions, and it was hearsay. It was 4 different evidentiary objections. You could throw in the confrontation clause for kickers. It was as inadmissible as anything could be. And now they got burned because they stuck that exhibit in without even thinking about it. But clearly, they had never really screened it, never really reviewed it. And like the other thing they wouldn't do is they wouldn't benefit from crowdsourcing. I was like, these days with all the autists on 4chan, you have all these different people out there. I had dozens of IT professionals volunteer to help to build a website for part of the court of public opinion. That too, of course, was turned down in all their efforts and got negated. But I was like, you got all these people were sending me stuff about this video going back months, saying that this was coming and saying how it would be wrong. And Richards just refused to, didn't want anybody else involved. And most partially ego and partially and misjudging the case and partially because he was always overconfident. And it may turn out that, God bless that jury, and they got a very fair jury. But as you noted, 5 of the 18 are wearing masks. That would be the kind of person you would strike. And there's a risk of a bad verdict because I won't go into details, but some of the jurors they were worried about were the jurors they should not have been worried about. And so if they may have struck people based on that were actually would have been good jurors. This is what happens when you have 3 liberal Democrats helping pick the jury. I mean, it's just, I mean, Joellen Demetrius has been sitting there the whole time, still pretending she picked the OJ jury. She didn't pick the OJ jury. Johnny Cochran picked the OJ jury. First, by guilt tripping the prosecutor for moving the case from the West Side to downtown LA. And second, Johnny knew the Black community exceptionally well. And he was a great defense lawyer, period. Whatever you think of Johnny, one of the best of all time.
Yeah, one of the greatest.
Absolutely. He knew if he got older African-American women that were mothers, they were going to come to the protection of OJ, and they were particularly not going to like all those pictures of the white girl who stole her from his Black wife, right? I mean, Johnny encouraged the prosecution to keep putting up those photos. The young one when 17, when she's like looking like she's at a car wash and things like this. I mean, they put up some really dumb photos in that case, but Johnny played it to the nth degree. That's why when they took a tour of the house as part of the trial, which is always a weird thing, but they did, he had Bibles in like every room. OJ probably had to open up a Bible since he was 6.
They brought the jury through OJ's house?
Yes.
What the hell would you do that for?
I forget what the excuse was, but there was some evidentiary excuse for them to see the property. And of course, Johnny used it to the nth degree. There's a Bible here. There's a Bible here. And you got the really, you got the used Bibles. So they look like they've been beat up, and Bibles handed down by grandma and great grandma. And you got them all there. Johnny knew what he was doing, but she's been pretending she picked that jury forever when she did not. Mostly what she's been there is she's been David Hancock's person to manage things because he's wanted control. And
she's the lady in the courtroom.
Yeah. And not the lady at the court table. She's sitting next to Wendy Rittenhouse in the back. Gotcha.
Okay. See, I don't know any of the backstory here. I'm just on the this is what's happening in the courtroom at the bench. And what I saw with just the evidence and the admission of evidence and the lack of objection to the fact that not only are you allowing a cop to testify that he downloaded a video from Twitter or YouTube, and what should happen in this case is they could say, this is a true and accurate representation of what was posted to Twitter and YouTube. And that should be the extent of their ability to bring this evidence before the court. But going further, how is this cop laying foundation that this is a true and accurate representation of the events of that night?
Exactly.
And
You could put up a doctored video on Twitter and YouTube. So there's a process. And my argument was bring in the witnesses, because there are only two people who recorded evidence that night video. One, people that are favorable witnesses that didn't like what was happening that night, whether it was Drew Hernandez or Richie McGinnis or any of the others, or
Right.
the some of the family members, et cetera, that were there, or they're commie lefties who are despicable. And so either way, you win by having those people have to authenticate any video to come in. And you really, in my view, only needed the video of Rosenbaum saying crazy stuff and then the incident. A lot of the other stuff I never thought was particularly useful anyway. But you had enough from those people to get it. And then you get to introduce it through Drew Hernandez. Then you force the prosecution, if they want to get it in, to put Drew Hernandez on the stand. They didn't want to do that. Put Richie McGinnis on the stand. They had to, because he was a complaining witness, though he's not complaining. They put him on the stand. And they didn't obviously want to put the little commies on the stand. I mean, they had bad enough with Pot Boy early on. So there was limit, but it was just not handled. They kept telling me all the way through that they had high-end video professionals. And I was like, let's share the evidence. Let's put it up on a box format. I have a bunch of experts that want to come in and help. Weren't even going to require a penny or nickel or dime or dollar up front at all. And they were just kept giving me delays and delays and delays, and then never did. And people thought that I was being critical because of my own disagreement. I didn't plan on saying a word. It was my fear of what has happened, and hopeful that maybe if I can say something, maybe these things won't happen. Maybe it gets back to enough people that can have decision-making influence that they fix some things. Unfortunately, most of them ended up not fixed. But Kyle did a fantastic job on the stand, completely undue risk to put him up there. And for people that are, who watch today, only because of his testimony, were they able to get in a bunch of lesser includeds.
Yes.
Those lesser includeds aren't there, but for him testifying. Not only that, it removed some arguments, because I still think, you could have argued that Kyle didn't know that Rosenbaum wasn't armed, because he had just heard a shot right behind him. And then Rosenbaum's running right at him. But you put Kyle on the stand and he says he knew he wasn't armed. I think some of that may be later recollection. I don't know how he could have known that before, but again, it was just, I get he's clearly innocent, and he communicates that innocence. And what your high school student said is what I heard as well, which is that people in the courtroom had zero doubts about the authenticity of, I'm glad it's now public, Kyle's PTSD on the stand.
Right.
That's been true from the get-go. I thought it should have been a part of it should have at least been considered as part of the trial presentation, because it changes the whole dynamics of how people perceive this kid. Not a cocky, arrogant, militia, none of that. A very naive, very idealistic kid trying to protect his community, where almost all of his family is from. Not just his dad. It goes, grandma, aunt, uncle, on and on and on, cousins, etc. Where he worked, of course, where his friends were, all the rest. And it was, again, Antioch's a suburban community of Kenosha. That's what that is. Everybody in Kenosha knows that.
Right.
So even Binger trying to make the point he wasn't from Kenosha doesn't really sell well to any reasonable jury from Kenosha. It'd be like saying, it's like he made a big deal about West Bend, Grambo being from West Bend. West Bend is like 10 minutes up the road,
Yeah. That's the difference between Twitter and the jury room, right? Those jurors know where West Bend is. They know where Antioch is. They're not, and you haven't seen anything. You've seen Binger try to frame Kyle as an outsider a little bit, and it's sounded pretty hollow, especially when it's like, I work here. I slept at and Dominic Black's like, he sleeps at my house. He calls me brother. I live here in Kenosha.
I think Binger didn't do that for the jury. He did that for the media and for the public and the press, because he knows, and that's why he didn't hammer it much, because he knows the jury knows that that's a lie. to pretend
Right.
West Bend and Antioch are not part of the Kenosha community. I mean, these are Milwaukee and Chicago fans that live in Kenosha, 2/3, well, a little more Milwaukee fans, but they consider themselves part of that extended community. So but yeah, I mean, it's going to come down to the big problem with provocation. Even though they were always going there, this was always the objective. I'd been preaching this for a while.
I mean, their whole case about this ethereal provocation, like the whole night is somehow provocative, and every action that Kyle has done leading up to this point for hours before the event somehow amounts to the provocation that he's not allowed to defend himself later is ludicrous. But that's what they've been selling to the jury the whole time, and Richard should have noticed
Completely. Well, I'd made it clear that this is where I was going because, like a good point that Legal Bites made on your earlier broadcast was that the bigger problem is that provocation is a legal hook upon which that broader moral narrative sells to the jurors that are prejudiced against Kyle. They hear the words provocation and they think what you're just talking about. Oh, yeah, he shouldn't have been there. Oh, yeah, he shouldn't have gone out. Oh, yeah, he shouldn't have had a gun. Oh, yeah, he shouldn't have been alone. Oh, yeah. I mean, on and on and on and on. And so, and for them, that was the biggest problem with the jury pool. There was about a third of the jury pool. There were 2/3 that were biased, but a third were hardcore. And these were people that wouldn't budge, that just wouldn't move off of that position because to them, that's what made it. It was this whole opening statement theme. All this violence, only one person shot and killed anybody. That's his point. And his point is, why does that happen? Because a kid was there who wasn't supposed to be there. But legally, he never had a foothold because there was no legal provocation. Because I mean, that's the problem with losing the curfew charge and now losing the gun charge is without either one of those, he didn't even have any theory for provocation in this broader sense of unlawful conduct and even being there. And because the problem is the jury instruction uses that such a bland word, and provocation, unlawful conduct, right? I mean, what does that mean, right? But to jurors are going to impose their moral narrative onto the instruction and extend it and expand it into a place it doesn't legally belong. That's why it was critical that instruction never be given, because then that strips Binger of the anchor he needs to show something in the otherwise he was just going to have to argue reasonableness. And that didn't sound nearly as effective as a broad word like provocation.
If they don't have the provocation instruction, they can credibly ask the judge to dismiss for insufficient evidence. The judge can deny it for sure, but then they've got an appealable order on this denial to go, no, there's not sufficient evidence here on the record. Here is the evidence that they've presented. Here's the record. The appeals court can review it. And, they may defer to the judge at the same time, but I think it'd be a clear error or abuse of discretion standard. I'm not sure, but they could say, no, I think it's got to be abuse of discretion, right? On that one?
Well, I mean, I think what's useful here is he does now have appellate issues. He's got mistrial with prejudice, which is on a constitutional violation, which is a compelling one. And he's got giving the provocation instruction based on introducing a blob of and calling it evidence. I mean, that's deeply problematic. And the other utilities, Wisconsin Supreme Court is a majority conservative court. It will probably I'm not sure about if there's an election between now and when, if hopefully never has to happen, but if Kyle's case gets up to the Wisconsin Supreme Court, if the court of public opinion is good and it's a 5-2 conservative majority, they'll reverse the verdict. And it's interesting that this judge, who's clearly, he's evidence that he has serious doubts about the prosecution's case. I've no doubt wouldn't have brought the case himself, of course. And I think he would have taken these protective actions had he known about the pretrial prejudice publicity. The second is, if they had really prepped him on provocation, he would have been ready to deny it, understanding it, particularly in light of the pretrial prejudice and the way in which it will be misconstrued and misapplied in this context, that it won't be applied in this limited way. And they won't, Binger, he won't stick to that limited way.
No.
He'll make the much broader argument. He might not make it explicitly, but it'll be there implicitly all the way through.
Yeah, he's gonna run all over the provocation. I mean, that Again, he's made his entire case on this idea. Because when you get down to the logical aspect of it, the idea that you're not allowed to shoot someone who's stomping your head into the ground, the idea that you're not allowed to shoot someone who's smashing your head with a skateboard, the idea that you're not allowed to shoot someone who's pointing a gun at your face, or in a weird way, Rosenbaum is one of the best cases, but also the worst cases, I guess, because stomping your head into the ground, hitting you in the head with a skateboard, and pointing a gun at your face is more compelling than the idea that this guy's just got hands and feet. But when you consider that he's run full speed, made clear threats to Kyle throughout the night, and got his hand on the barrel of the gun itself, and that is shown by the medical examiner, we can say, okay, no, someone grabs your gun, you shoot. Because if you don't shoot, they grab your gun, they shoot you, and they maybe shoot someone else. And you're reasonably allowed to think that that is the default position of someone reaching for your weapon. And you can ask any cop on earth, and they should have asked this to the detectives on cross. So you, as a police officer, someone grabs your gun, you pull the trigger, right? You shoot him, don't you? You don't want to shoot him. Of course not. You're a police officer. You're out there to protect people. But if someone's unruly, if someone's crazy, if they're running at you full speed and they get their hand on your service weapon, you have to pull the trigger, right? And of course, those cops are going to say yes. You say, that's what happened with Jacob Blake, wasn't it? Jacob Blake's getting into a car. That car has become a dangerous weapon. You have to pull the trigger. You pin these guys down who are going to be favored in pulling the trigger and make them say that that's exactly what's going to happen, especially if they're going to have Kyle come testify.
Well, because one of the other myths of Binger is that these were unarmed. By law, if you grab somebody's gun, you're armed. So because, I mean, that's, in fact, there's cases on this. When you grab the other person's gun, you're considered armed with a dangerous weapon because now you have the control or the capacity of that weapon going off in some manner. So both people who were shot at the time they were grabbing Kyle's gun, and the third person had a gun. So that's one part. The second part, of course, is what Kyle, they needed to expand on this in the opening statement. What Kyle understood was the reason why he's running is a combination of Zeminski and Rosenbaum.
Mm-hmm.
So he sees these two people are out to kill him, and he hears a gunshot behind him. So he knows that unless he defends himself right then, he's dead one way or the other. Now, the good point I'm glad he made, which was a point I wanted him and the defense to make, was he emphasized, I mean, he's done a better job defending himself than Richards has defending him.
Absolutely.
He said on the stand, they're going to kill the gun. He said they were going to take the gun, kill me, and likely kill others. And that was one of the themes I wanted to put in there. There was no active shooter that night. But if Kyle hadn't defended himself, there would have been. And that active shooter would have been Joseph Rosenbaum, a guy just released from the nut house with mental issues, who was engaged, who said he wanted to kill all night long. What if he has that AR-15? Where does he start aiming it? This is the guy that was setting fires wherever he could, including next to a gas station. So that's where I thought large parts of that. But Richards will be doing the close.
Oh,
it was Richards' idea, by the way.
Right.
That was all Richards. That was not
him closing. I'm going to need a lobotomy after 2.5 hours of his close. There's no way it's going to be any good. I mean, maybe he'll surprise me.
I hope and pray he does the best ever defense. And part of the reason why I've been publicly critical is the hopes that parts of it linger back and it motivates him in a positive direction to put on the best defense and then prove Barnes is just an asshole. And go up and give the greatest ever close because it needs to be done. But it's not his natural instinct. Unless somebody helps him with it, I'm not optimistic. And Binger will do a sleazy, swarmy close. And then it does all depend on the jury. Unless they screwed up and deliberately removed good jurors and put bad jurors on, I cannot see convictions on the homicide counts or the reckless endangerment counts, because the nature of these reckless endangerment counts, self-defense is a full defense. It's only if he had hit somebody that was out, like if he had hit McGinnis, then that would be reckless injury, and self-defense is not a defense as to that. But he did reckless endangerment. It does have a full, complete defense of self-defense.
And there's a hopeful element in the judge saying, you know, I mean, he put all 4 rounds. Judge even says it. He puts all 4 rounds on target. I'm kind of confused on how this is reckless.
Yeah.
Like you should be confused, Judge, and you probably should dismiss the charge because, well, I mean, I guess no, that's actually J and OV fodder, right? If they find self-defense in the shooting of Rosenbaum, but they try and do a compromise verdict on the reckless endangerment, that's when you make a motion for J and OV. Your Honor,
I mean,
they found self-defense here. There's no way they can't that they can find that he was recklessly shooting this guy. All 4 rounds were on target. I love Krause's like, well, not all of them. One of them only grazed him. It's like,
yeah. Well, I mean, the other thing is the 2 reckless endangerment counts. One, there's been no witness to testify for that. The so-called complaining witness never showed up in court. No testimony on that. So did he feel recklessly endangered? I mean, you have a victim who's not a victim, who's not even in court. And then Richie McGinnis said he was out of the way, that he did not feel imminently in danger. He stepped out of it before the shooting occurred. So in my view, there was sufficient evidence for him to give a directed verdict on there. And again, these are things he may have done if he'd known about the pretrial publicity, if he'd understood the risk. And because the other aspect was putting the basis for misconduct. Richard specifically told me not to say anything about Binger or go after Binger, because it was my idea from the get-go. I want to look at all of his cases and see if there's an extended pattern, because there almost always is. The guy was already misusing and abusing bail proceedings, misusing and abusing evidence proceedings to libel Kyle, to create pretrial publicity and prejudice. And he was like, no, he started yelling at me. He lost his temper. So that's when I was like, okay, it's going to be like that. But
if he doesn't, go ahead. Sorry.
I'll say if they had planned, because this is a guy that has a history of it, number one. Number two, was doing it in bail proceedings, constantly lying about Kyle. I mean, lied about the address disclosure issues, lied about Proud Boys associations, lied about a whole bunch of things that he knew Kyle knew nothing about, lied about the okay gesture, lied about other aspects related to that, then lied in evidence, said certain evidence was going to prove certain things that it didn't, introduced it solely to create pretrial prejudice, knowing the judge was never going to allow it in. And then on top of that, misleads them in the opening statement, tried to suborn perjury by the witness who testified about their attempts to get him to change his testimony, and quite frankly, obviously did suborn perjury, because I mean he put those car source people up on the stand, had to know they were lying on.
Oh my gosh,
pathologically. So you build the predicate of that, you braise it every single time with the judge. How much abuse are we going to have? How many violations are we going to tolerate? Are prosecutors above the law in Kenosha? Just over and over and over, so that when he crosses the line on the Fifth Amendment issue and then crosses the line on an evidentiary restriction issue, he's ready to pull the trigger. And again, he's ready to do so because he knows there's pretrial publicity that makes it tough to get a fair jury. That's good. Like, his whole thinking is, this is going to make Kenosha look good. The kid will get acquitted, prove what the facts are, all done. But if he knew the jury had pretrial publicity that prejudiced them, then he's like, oh, I need to step in and I need to fix this now. I need to correct this now. I don't want Kenosha to be embarrassed again by hanging an innocent kid because of what happened. And that's where because he didn't know that one fact, it unraveled a whole host of decisions he could have made that would have been in Kyle's favor.
Now, one of the things I wanted to ask you about is, I think Binger made a critical mistake on the cross-examination of Drew Hernandez, who I thought Drew did he did great on direct, but on cross, he came across very unbelievable, very biased. I think he was way overselling his position there personally. But one of the things that happened is Binger brings up the political issue. He brings the case to a political nature. I think that was a big mistake for him. Hypothetically, you're on the team. Are you focusing a section of your brief on the fact that this is clearly a political trial, has always been a political trial, and the only person to raise the political issue in this entire case is the state when the testimony is inconvenient for him? How do you approach that?
Well, and that this was a political weaponization of the prosecutorial process for a personally ambitious prosecutor that would never be brought by 99 out of 100 prosecutors. It wouldn't have been brought by almost any prosecutor in the rest of Wisconsin. The head DA was scared to bring it. The head DA, he loves to try high-profile cases. You couldn't find him within 100 miles of the courthouse during this trial. And now he shouldn't have allowed it to go forward. But it's a testament to that. It's clear Binger has political aspirations and ambitions. His connections to various people by family ties and otherwise in Kenosha is well known. There's other ties. Binger bats both ways, and there's some interesting stories there too. And some corruption issues and relationships with public officials that he really shouldn't be having all of that. And but what Binger always knew is he knows Richards. So that's another reason for Binger's confidence, misplaced confidence. And sometimes his ego is so big, his arrogance exceeded his intelligence, like when he asked Richie McGinnis one too many questions and I thought the three most memorable moments in the trial, and two of the three were, one was were on state witnesses. Binger asking McGinnis, well, you don't know what Rosenbaum was thinking. He said F you and tried to grab the gun. That was great.
Brutal.
That was beautiful by McGinnis. Beautiful.
Yep.
Then Gabe, then Gaby boy getting up on the stand, Mr. I want to be a violent commie, pretend to be a medic. Can't really get my gun license because of that latest crime I got accused of. Not because I forgot to send it in the mail. Admitting, oh yeah, that's true. When I had my hands up, he didn't shoot. When I went for the gun and pointed at his head, I guess then he shot. And then his roommate lying and perjuring himself on the stand. Oh, I just made it all up. Yeah. Right. And then the third, obviously, being Kyle's ability to communicate his honest emotions on the stand and stay even keeled, which is tough to do. And Binger misread that because Binger never understood Kyle is why he couldn't cross Kyle effectively. Because he took him as this arrogant, cocky militia. He was never any of those things. Purely naive, purely idealistic. And then trying to make this a Call of Duty case. Call of Duty? You're going to play Call of Duty? Are we back to Gore in the 1980s? I mean, what a bunch of insanity. But Kyle really did a fantastic job, but he never should have been put under. You put an 18-year-old under that much pressure I mean, that's just unconscionable. And as Robert Grueller mentioned, they didn't even hug him or do anything when he walked off the stand. It's like he doesn't exist, and you have to have a personal, impassioned relationship with your client. And it's easy when he's as innocent as this kid is. I've had a few clients that's not so easy, but this kid would have been the easiest in the world, to give him a hug and acknowledge him and thank him because the jury's watching. Also, just because it's the honest way. I mean, the kid was clearly still shaking when he got off the stand. You could tell by the way he was walking around.
Well, he just got grilled by I won't say too much. He just got grilled by a Binger, right?
Yeah.
He just sat there for they put him on the stand for like an hour, and then Binger got 2.5, 3 hours back at him.
4 hours when you add it all together. It was just on and on and on and on and on. And he was trying to break him down and try to ask God, the lack of objections in this case is mind-boggling. Just mind-boggling.
What about
there too? If the judge knew pretrial publicity, he's a lot more careful about what evidence he lets in. He probably intervenes himself, as he occasionally did.
Right.
But he would have intervened more often to say no, 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 and no.
What about the big fumble that at least I perceived it as a big fumble on Rosenbaum's girlfriend and Huber's aunt or great aunt or whatever? Both of these, the state is stupidly offering witnesses that clearly have no purpose other than character. And they don't, first of all, they object. The one time they object when they shouldn't. And that's when she's saying he's a good boy who runs towards fires. You should have withdrew that objection immediately. It's like, no, actually, you know what? We withdraw that objection. Let him go ahead and talk about what a great guy he is. And then read the charges once the jury comes back. By the way, he's a good boy. You said you just moved back. Do you remember his criminal charges? Like you just ask. And then with Rosenbaum's girlfriend, she opens the door because she says, bipolar disorder. He took his meds. I think they're for bipolar disorder. Well, why do you think that? Well, where was he that night? You said he came home from the hospital. Do you know why he was in the hospital? Was it related to his bipolar disorder? And then you work your way back. Does he have a history of violence? Why didn't he stay there that night? Why didn't he stay at your house? Does he have a history of this? Did you know about this? I mean, you probably knew a little bit about this, right? And you're trying to help him work through it. And I know things don't always work out. People aren't perfect, but you knew about his past. Can you tell us a little bit more? You just get there by steps.
Well, there was a temporary restraining order on him because of his violence against her.
Exactly.
So, I mean, there was extensive. They opened the door, like it was clear on Huber, because they go on this extensive objection, and they say, well, if they open the door, here's what we're going to introduce. And you know what Binger thought of that, because they immediately withdrew getting into that at all. So it's obviously the edge was let him open that door and hammer it home and walk right through it. But
did you catch this moment by Richards? I didn't catch it live, but Richards, thank God, told the judge when he was bitching about something, because when he talks to the judge, he's usually pretty good, but he does get pissy from time to time. He did today.
He has a hot temper.
Yeah.
I've witnessed it firsthand.
So Richard says to the judge at one point, and this blew me away. He's like, I went up and I whispered to opposing counsel, stop this line of questioning or else I'm going to go here. And then he did. And it's like, why on earth would you do that? Just this is a murder trial. This isn't like you're working out a plea deal on a petty theft. Like, man, give no ground. This is murder. If this kid loses, he goes to prison forever.
Yeah.
Oh, that torqued me off.
It was mind-numbing. I mean, all the irrelevant prejudicial evidence they let in, all the mishandling of technological video presentation, the gamble of putting Kyle on and the ways in which that undermined aspects of the defense inevitably, despite how well Kyle did, and not prepping the judge for the risks related to pretrial publicity, evidentiary issues, and provocation, put Kyle at undue and unnecessary risk, where he has to hope that that God bless that jury. Because seeing everything else, I have zero reason to have any confidence in how they picked the jury. One, they just didn't ask enough questions to even know information. Two, the questions they did ask were information they should have got from data, which means they didn't do a meaningful data deep dive on all these people. And then third, just watching the rest of the trial presentation, there's no reason to have any confidence in their jury selection. And so and people thought, well, maybe people are throwing it. It's nothing like that.
No,
this is a combination of ego and limits on competence and capability. And I think people saw through the trial what I talked about. Richards is a good fact guy, not a law guy, not a narrative guy. And consequently, not good at objections, not good at jury instructions, not good at opening statements, not likely to be good at closing arguments, and sporadic in his cross-examinations, and sporadic in his direct examinations. Because you saw with the video guy, that should have been very effective testimony by the expert. And instead, it ended up being, him taking
insufferable.
Because he dives into these facts in weird ways. He needed somebody else to craft the narrative for him. He could still perform, but he needed someone else to help him with that. And thank God the Corey guy was there, because he's good at cross-examination.
He's very good.
Still doesn't object nearly as much as he could, but putting that aside, very good at cross-examination. Otherwise, this would have been a complete disaster. God, in terms of trial presentation. Now, the thing is, because Kyle is so innocent, the facts are so on his side, and the law favors him in Wisconsin. That's what gives him a good chance. But you have the gamble of whoever's sitting on that jury. One last in provocation, two things. You were right about the gun charge all the way. We've been talking about this all the way through.
Yep.
That I remember arguing like 2 days afterwards, saying that the only thing that's banned is a short-barreled rifle. And the best way to explain to the judge was simple. In Wisconsin, they did not want to ban guns on the farm. They didn't want Junior to not be able to have a gun on the farm. So shotgun, rifle, no problem. Anything like a handgun, anything like a short-barreled rifle, anything like that, different dynamic, because they were thinking about urban violence. when they passed that law. That was what it was all about. Milwaukee handgun violence, especially. So they were always going to make, especially Wisconsin, 65% of Wisconsin lives in rural areas or small towns by census definition. It is one of the more rural states in the country. It's why Trump almost won it, even when he slipped further behind in Michigan, because Wisconsin's more rural than Michigan is. Similar like Minnesota. I mean, if it wasn't for the Twin Cities, Trump would have had a chance, but Twin Cities.
Oh, yeah. I live in like a +5 Republican county. We have a Democrat congressman, but the only reason we do is because he's the chair of the United States Agriculture Committee. So it's like the farmers out here, they love him on his ability to get them subsidies. they don't care so much for his politics. And he's never a he's only ever a deciding vote when they have no one else. But no, it's this whole thing. And to give Richards and Sheriffisi some credit, because I don't want to shit on him too much. Sheriffisi actually doesn't deserve much ire at all. He's been doing whatever he has.
Richard should have kept his mouth shut during jury instructions, because Corey was doing just a fine enough job on jury instructions. That's his kind of area. He's more of a law lawyer, and he was persuading the judge, as you pointed out, until Richards decided to go.
Stupid. Did you hear that Corey Sheriffisi today actually slammed Richards? He did. It was subtle and it was brief. I don't remember exactly what he said. Maybe I can find it at some point. But he said, if I was doing this part, I would have done it this way. And it was like, that was a little bit, that was bordering on unprofessional, but I think it was merited. But he basically said, if it were up to me, we would have done this part completely differently. And that was a neat moment. But no, to give them, if this were not Kyle Rittenhouse, if this were a bog standard self-defense claim, I think a lot of the concerns are a lot different in going on. And I don't think that some of the things that have come up would have been as big of an issue, but you keep pointing out that a big part of this is the pre-trial prejudice that the jury has. They're coming into this, and we've seen this, even people in town probably don't even know who he killed, right? They're just like, this guy went there armed hunting. I get comments on these live streams where people are like, he was there hunting people. It's like, oh my God, then I don't know what you're watching. Because if he's hunting people, he did a terrible job. If he's hunting people, he should be up on the roof sniping people where no one can find him. Maybe I shouldn't tell how I would do it. But
it's how the revolutionary guy did of cops in Dallas.
Yeah.
It's the other thing with that on the provocation side. What provocation really triggers under these facts is a duty to retreat. That's what it does. That's why they got the duty to retreat instruction in too. And the problem is it just confuses the jury and creates the legal anchor by which those who prejudged Kyle can argue for conviction in the jury room. And that's where the big gamble now is. And it's So we'll see. Hopefully when they do that random draw hopefully they do it the way I've seen some federal courts seem to somehow do it. And those 5 masked people just magically, God just kicks them out of there. And they're 5 of the 6 that are bye-bye. But that's, anybody that's wearing a mask voluntarily, chances are not good that they're a good juror.
Yeah. And now I did see they literally have like a bingo tumbler. That's what they after the courtroom, they had that thing on display. I don't know if they picked them today. I think they pick them after closing argument. But it's literally bingo tumbler. They put the names in it and there's a crank and it turns around. So hopefully that works. But I was going to ask something and now I lost it. It probably.
See, the media narrative is already, if the African-American and Mexican-American, I think there's one African-American, one Mexican-American on the, which by the way, mostly reflects a little underrepresented, but mostly reflects Kenosha. Kenosha is a white working class community, middle class community. It's a little more middle class these days because you've had some more people that are work in Chicago or work in Milwaukee, live in Kenosha.
Sure.
But still sees it as very middle America, heavily ethnic. Typically, a typical Kenosha jury would have out of 12, you would have 4 Germans. You would have 1 to 2 Polish, 1 to 2 Irish, 1 to 2 Italian, 1 to 2 Mexican Americans. It's actually about 10% of the population now. And I think they have very liberal jury selection methods. I think it's driver's license, or in Wisconsin, it's like if there's any means by which you show up anywhere in the state as possibly being a resident. That's how that woman who was a resident in Chicago got pulled up, because she was still listed in one of their old, unlike federal court where they're much more restrictive of who gets in there. That's how it would be. But particularly if the African American or Mexican American doesn't make it in the final 12, they're already prepping it. Twitter was promoting it yesterday. It'll be all white jury will be the lingo. It will be used if particularly if there's acquittals, because they're already prepping that logic. But basically the provocation instruction created undue problems, undue risks. Hopefully, my instinct is still strong towards mistrial. I'm still hopeful of acquittals, just in the belief that they got some good blessings with the jury. I cannot see convictions on any of the homicide counts, even the lesser included. I can't see it.
I can't either, except in my like deepest, darkest pessimistic ways. But no, I think again, the law and facts are so far in his favor. I think I think any convictions we see are going to be a compromise verdict. And
I agree.
That compromise verdict for the chat just means that, they don't want to convict him on the big stuff, but they want to convict him of something. Something has to have been done wrong, and therefore we're gonna find something. So they grab one of the lesser included offenses on the attempted reckless homicide. And I think Corey Shearvizi's right on that one. I don't know how you attempt recklessness like that. That doesn't make sense to me. But are you going to be available? Are you going to be around on Monday for the? Okay,
I'll try not to be. I hope it goes well, because otherwise I'll probably be climbing the walls again. But that's because Viva was talking about doing a live stream after the closing arguments, and I was like, it's probably going to depend on my mood. It might not be a great idea if I do it, because today I've been agitated all week, and I've got tons of other projects that I'm in the middle of, and it's just been nonstop work because I can't, because I was concerned about this case, wanted to see it go a certain direction, and still hopeful that at some level it does. I can tell you that media people that are there, like what your high school student said, the media people that are there thought almost guaranteed he would be acquitted of all the homicide charges. Yeah, now, that was before today, but I don't think they're going to process today necessarily. But that was their take. They in fact, and a lot of the protesters think Binger's secretly throwing the case.
So, yeah. I mean, to be fair, that's been the funniest thing. The best evidence for the state has come from Kyle, and the best evidence for Kyle has come from the state. It's like a backwards law. Now, I want to ask you like one more question. A lot of people have been asking me, and I don't know how to answer this. Why not go with a bench trial with Judge Schrader?
Oh, prosecution never would have agreed to it. In Wisconsin, they have to agree.
Okay, so that makes sense. I wasn't aware of that. So in Wisconsin, the prosecution has to agree. If you're going to go bench trial, they can demand the jury trial as well. That makes a ton of sense. Yep. Because normally I would say, well, you go for the jury because you really comes down to 1 in 12 or better odds than 1 in 1. So I'll take 1 out of 12 jurors on the idea that I can convince them, because you get a judge, and sometimes your legal case, even if it seems strong, is not 100% sound, or you get a judge who's just wrong in the law. As you probably know, some judges just don't know the law. And Schrader seems to be pretty good on it, although not on the, I don't know if he's bad at some of the rules of admissibility of evidence, or if it's just how bad Richards did at objecting.
It's two things. One is Schrader's reputation is a let it all in guy. Mm-hmm. So let it all in for jury instructions, let it all in for evidence. So that's his natural instinct. However, he would have been much more aggressive if he would have understood the pretrial publicity prejudice. Because number one thing he wants Kenosha to prove to the world how good their community is. But he associates that, I believe, with acquitting Kyle. He does not associate that with them being someone to lynch an innocent kid because of this. So now he kind of assumes things about his community that are broader than you see that in him making the joke about the Long Beach ports, right? That's
Right.
the world in which, or having his ringtone, proud to be an American, right? He comes from a very different generation.
Yeah.
And he acknowledges that, publicly. I always called him a Southern judge who happens to be in Wisconsin. Because if you understood, he's amazing how much he's like that. But if he would have known of the risk, he would have been less open than he was. And as you saw how many objections he sustained, he would have sustained any objections they raised. What it was is he basically gave them the power. You tell me what needs to come in and what doesn't. You tell me what the risk is. You tell me whether I can be a little bit more leeway to the prosecutor for the court of public opinion because the jury's already with you. He was giving that trust to Richards. And the problem is Richards has misread the community. He may end up fortunate in the jury matching the jury he thinks it is. But honestly, it'll be good fortune. It won't be good strategy.
Again, the idea that a detective, and I stopped, we were talking about this before and we got off on another tangent, but a detective can testify not only to the authenticity of something that he downloaded, but then proceed to give eyewitness testimony about what he's seeing and characterize it in a particular way. And specifically to say, well, I saw him raise the gun when I pinched to zoom on my iPhone, something that can't be replicated or produced to the defense, and that they're not going to object to that as a matter of course and say, Your Honor, we don't know what he saw. He can't even reproduce the amount of zoom that he gave. We can't get this video into evidence. They haven't produced it. We haven't had our expert able to review it. The fact that they allowed him to say those words without objection is one of the, again, it's one of these areas where I always struggle to say malpractice because it could be a tactical decision. But to me, it's like, this looks like malpractice.
It was. I mean, what advantage do you have to have that evidence coming in? What advantage do you have to this blot evidence coming in just because you didn't understand the technology well enough to impeach it and didn't prep the judge enough to know how to keep it out?
Print off the Wikipedia article and hand it to the judge. Judge, this guy, their expert, can't tell you with bicubic interpolation how this red and the blue thing is, what color that next dot is going to be. On Wikipedia, it tells you with this type of interpolation exactly what color it's going to be. It's going to be purple. Of course it's going to be purple. It's going to create a color that isn't there because that's how this works. It's not only available on Wikipedia, but this guy's an expert and he can't explain it. How stupid is this, Judge?
Plus, they should have had the video evidence to rebut it ready to go.
Yes.
And to be able to show them right there and say, this is clearly false. This is completely false. Though Binger opened the door when he was sitting there saying, oh, I don't know where Zeminski is. You can't really see much in this video. That's the point. And the point, like Corey made it decently, it could have been made a little better in the sense that the point to make to the judge is there evidence here that is sufficiently clear that a reasonable juror, beyond a reasonable doubt, could conclude provocation?
Right.
It's nowhere even close to that standard. It's attempting to misuse technology to lie to the jury, to inflame them in a particular manner that's legally irrelevant. And if the judge knew the background of a big problem with pretrial publicity, he'd excluded it in 5 seconds. He would have rejected the provocation instruction in 5 seconds. This was failing to understand the risk of pretrial publicity is the primary reason there's risk right now. Think about all the other stuff. Of course, putting in your own exhibit that had this in it, just monumentally stupid. That's clear legal malpractice in my view.
Yes.
And then letting in all the prejudicial super chats and then all the prejudicial hearsay. There's hearsay and now people understand the significance of it, of that guy, of different people saying that, pointing out to Kyle, he pointed a gun at me earlier that night. And there's the one guy he said yes to sarcastically, but if you actually listen to the videos, that happens repeatedly. So none of that hearsay should have been let in. None of those super chats should have been let in. They associated Kyle with the militia. They associated Kyle with people saying, way to take out the leftist trash. They associated Kyle with saying, this is what democracy looks like, LOL. All those things. And I mean, like the TikTok. There was no his photo could come in. There's no reason for his tagline or the title to come in. There's no reason for that. We know that it's what a teenage boy jokes about, but the jury could easily misconstrue that, easily misunderstand that. What was the relevance of that? How was that not more unfairly prejudicial than meaningfully probative?
Right.
Just mistake after mistake after mistake after mistake.
And the one thing I was like, I think how they would have won the provocation argument today was simple. And they spent way too much time on it. And all they had to do was say, Judge, at the beginning of this, they gave you a picture. And that picture, you said you can't see anything because it's a blob. You have seen a blown up picture. It's giant for you, Your Honor. And you've said it's a blob. It doesn't show anything. What the state is not telling you, because they've now said that that's their worst evidence, even though just a second ago it was their best evidence. Now they're saying the best evidence is a video. That picture, Your Honor, is from that video. You just said you cannot see what's in that picture, and it is the one frame that they picked, the best frame that they could possibly find to make their case. And now they're saying, oh, no, you have to see the video, but that is from the video, Your Honor. So that by definition has to be their best evidence. That's why they picked it. And if you can't see it there, there's no way you can see it on the video, and there's no reasonable jury who can see that. And that's all that, to me, that's all they needed to say. When they say, oh, well, you have to see our video, you just say, actually, Your Honor, that's from the video. We don't need to see the video. It's right there in front of you. You can't make it out here. You can't make it out there.
And if you can't make it out, that's not sufficient evidence for a reasonable juror to conclude beyond a reasonable doubt that that's what it is. Because technically, that beyond the reasonable doubt applies to everything. It's every single factual determination they're making is beyond a reasonable doubt. And so you conclude beyond a reasonable doubt that Kyle picked up and lifted the gun? Would a reasonable juror, beyond a reasonable doubt, not Binger, a reasonable juror, conclude beyond a reasonable doubt that that is Kyle pointing a gun when you, the judge, are saying you can't see what the heck it is, and frankly, nobody in the room can. And and as you mentioned earlier, you're not even allowed to let the jurors look at something over and over and over again, right? And we're sitting here looking at it over and over and over again, and we can't identify it. That ends the debate. Just like the law is void for vagueness, if you're confused about what it means, it's only an unreasonable juror could conclude beyond a reasonable doubt that's Kyle Rittenhouse pointing a gun at somebody.
Strategically, the judge has ruled that the evidence or the instructions coming in, and then 5-10 minutes later, they're having the discussion that it's unduly prejudicial to give the jury unfettered access to the video. Do you say, Your Honor, I know we've gone over this, but I just want to draw attention to the fact that that's what the state had to do to get the provocation instruction. Do you risk saying that? Because it's a risky proposition to try and relitigate. But
if it's up to me, I mean, depending on the circumstances, how you read the jury. But my view is very tough to read the jury. And if you knew, though, about the pretrial publicity, you would be just seeking mistrials all the time throughout the trial. Make it be a perfect trial. Until then, mistrial, 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 mistrial. Unless you thought you would lose this judge, which I don't think there's any reason to believe. This judge will be there until he's no longer living. Retirement ain't in his DNA.
No, and so he'd be long gone.
Exactly. And so and there'll be pressure on Binger not to bring a retrial, depending on how things flesh out. But this was supposed to be a shining moment. Instead, he got lectured by the court, and the left thinks he's secretly sabotaging the case. So his one audience is not his audience that he thought it would be, not his cheering audience. And so he may reconsider how eager he is. And Grosswitz is locked into what he said. He can't take that back. Key evidence you've already got locked in. My guess is second time around, those car source people probably just take the fifth and stay off the stand rather than be dumb enough to commit another round of perjury.
I can't believe they got up there in the first place if those are the answers they were going to give.
I would have subpoenaed their tax and financial records of them and their entire family. I would have put the sting on them quickly. And we did that in the Snipes case. I mean, we subpoenaed a lot of people, a lot of evidence, because a lot of people were going to get up there and tell fake stories. And then when they knew we were going certain places, they suddenly decided they didn't want to testify or didn't want to tell those fake stories. So there's ways in which you can do that. The other thing is
subpoena the insurance claim. You filed an insurance
Oh,
claim.
absolutely. And in the insurance policies and all their internal communications about everything that happened, all their texts, all their emails, everything discussed related to that event. I guarantee you they said some dumb stuff. There would have been a lot of evidence, track records, digging. I mean, they clearly had tax fraud problems. They had financial abuse issues. They had insurance fraud issues. They had to cover their rears beyond just the obvious of not wanting to accept responsibility for hiring Kyle. They wanted to. It was more than that. When you can't say what your job really is, and you're not sure which place you really work for, I know what that is. And usually those people suddenly decide, we'll just take the fifth rather than lie on the stand. And so there are ways to have handled that.
I can tell you the limits of their inventory policy on their insurance. It's $400,000. That's the limit. They testified directly. It was $400,000. The other day it was $2.5 million, and you're talking about losing 130 cars, plus a building, plus you've got ground damage. You're going to have to do some re-asphalting of a giant lot. Yeah, there's no way that's $400,000. And someone said that averages out to like $2,500 a car, and they tend to sell cars apparently around the $3,000 mark. So maybe that's plausible, but it's like, you've got a whole building there, and that's a $500,000 building. Easy. It's a big structure, and it's a commercial structure. They cost a lot because it's a business, and it's like, and they've got equipment in there. They've got this is a used car dealership. They've got computers. They may have some sort of service and maintenance shop there. Who knows? But $400,000, what they testified to under oath the second go at it, that's their policy limit, is my guess. But
and almost every insurance policy excludes civil unrest, arson, things of that nature. Now, they probably didn't necessarily fully know that the first night, but I bet they found out by the time they wanted to hire people. The problem was they were so cheap, they didn't want to hire professionals, because I mean, these are people that operate on thin margins. So it's saving a little bit here and not paying some tax over there that gets them to their profit. And it's interesting that the dad runs everything, but he doesn't speak English.
And the inventory manager doesn't manage the inventory because the dad does. The other guy,
mom owns some businesses. Is mom claiming to be the owner for the purpose of getting certain federal loan policies? Maybe certain small business investment, certain other banks. So my guess is, with this kind of family you dig, you're going to find fraud. And you could have made sure they never got up and told that fake story. Now, I don't think it sold with anybody but the most hardcore Kyle hater on the jury, because it didn't take a lot to figure out, man, these are people that are shifty as the stereotype suggested, and in that community. So, but it just could have. This was a case that's set up for a dream team defense because of how compelling the client was, the facts were, and the law was, and they've unnecessarily jeopardized it. Hopefully, for all of us that care about self-defense or care about the kid, they ultimately, that doesn't matter. And like I said, a little fairy dust on that wheel for jury selection, a little bit of God's blessing, and the verdict is the right verdict, regardless of Forrest Gump defending it.
Well, Robert, it's always such a pleasure to have you on. I always welcome your wisdom and your insight. I'm going to go ahead and read through a bunch of chats. And I'll let you peace out. I'll definitely have a link for you on Monday if you want to pop in. And I think Monday is going to be an explosive day. And I think we're going to have a whole lot of people watching. So.
Yep. And I just hope Richards does the best presentation ever. And I hope Binger is exposed as the swarmy, sleazy scuzzbag that he is.
Absolutely.
And then after that, we can get back to the most important thing, disbarring Binger.
Disbar Binger. All right. Thanks, man. See you soon.
So pour out another bag of Balmore and Lafroig. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Planning tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the law what we have now.